Meet Bill and Mary Jones. They have two children, Susan and John. They live in the Pasadena area. They have a home, some money in the bank, and a small retirement plan. Bill has decided to retire. Now that he's retired, Bill finally starts to seriously think about his health, and he begins an exercise program. Unfortunately, as a result of that sudden starting of an exercise program, he has a stroke. He is now disabled and will need long-term care. Mary is particularly worried about how she's going to pay for Bill's rehabilitation. Though Bill had health insurance, he and Mary did not realize that long-term care disabilities are not covered by regular health insurance. To pay for Bill's care, Mary starts reviewing the largest assets which she and Bill own with the thought that she may have to sell them or liquidate them. The assets consist of their home and an IRA, which Bill started through his employer. Mary goes to a real estate broker to sell the home, which she and Bill jointly own. However, she's extremely surprised to find that though she jointly owns the home with Bill, she cannot sell the home unless Bill is capable of also signing the sales agreement, which he is unable to do as a result of his stroke. She next tries to cash in the IRA, but soon finds that she can't do that either. The IRA administrator informs Mary that though she is a beneficiary of the IRA is in fact owned by Bill, and Mary cannot access the IRA unless Bill is deceased. Mary then seeks the services of an estate planning and elder law attorney. He informs Mary that she has no other alternative but to seek an order from the Superior Court by going through an extremely expensive conservatorship proceeding to gain authority to control the assets that she and Bill created. Unfortunately, Bill's life and their assets will now be governed by the court. 7 out of 10 people over the age of 65 will have long-term care health problems. And if they're not prepared, they can easily join the 66% of all bankruptcy filings which occur directly as a result of medical bills. The attorney explains to Mary that most estate planning attorneys do not have elder law training in long-term care asset protection. The estate and elder law attorney also explained to Mary that if she had consulted an attorney whose practice centered on not only estate planning, but also included long-term care planning, that all of the suffocating medical bills which she and Bill are now burdened with could have been avoided, and their estate would be protected for Bill and Mary's use, and the remaining assets would be passed on to their children. The attorney also raised other issues that she and Bill never considered, like, do they have health care powers of attorney? What if Mary was in an accident and not able to make her own decisions? With Bill disabled, who would have legal authority to make medical decisions on her behalf? Have they set up durable powers of attorney so that someone they trust would have the authority to access their funds and continue to pay their financial obligations if they should not be able to do so for themselves? Do they have a plan to protect their family's assets for their heirs if one of them should die and the survivor remarries? Will their assets wind up with the new spouse's family? The attorney also showed Mary the wisdom of creating an estate plan that is customized to take into consideration the needs of their family as well as the requirements and needs of each family member. The attorney explained that all this could be done without having prolonged and expensive court involvement. Hopefully, Bill will ultimately recover, and if he does, he and Mary can then create a well-crafted estate plan which will give them peace of mind and allow them to rest easy, knowing that each of them will be protected if one of them becomes ill or dies. The attorney provided a clear explanation of how having a plan in place and not leaving their lives to chance will make each of them feel more confident and in control of their family's future. Contact the Hayes Law Firm today to learn about the different estate planning documents and strategies that will work best for you and those you love.